Hi, good morning. Good morning. Oops, I have the wrong title. Well, it's not exactly perfect, is it, darling? Because you fucked up the title. Do you see it? Yes, I do. Do you see it? Yes, I do. And then we're only doing, what are we doing today? And not grilled. Okay, so who's grilled now? And Garland on the grill. I think it's the Judiciary Committee. Okay. And Garland on the grill. Okay. Done. All right. Good morning. It was fun. Oh, I was definitely able to rest. Oh my gosh. Yeah. And I got something done I really needed to get done around the house. So it was actually quite nice. Oops, my title's a little weird. So actually it was really, really nice. I got a lot done and I got some rest and I got to bed at a decent hour and I actually slept. You can see the results. I haven't had coffee. I haven't poured my coffee yet. I brought my coffee pot in my room so that I could get here. Now, I will say, I forgot to set my alarm. Ooh, thank you so much, Lee. Thank you. I could feel your support yesterday. I just want you to know that. I could totally feel the support from you yesterday. I just want you to know that. Thank you for that. Thank you for all of you who help, just send good wishes. Like I just can tell that you are, I'm just really grateful for it. I'm just really grateful. I'm just really grateful for anyone who, I don't know. And Lee, you and I have been together since the very beginning of this. And anyway, I'm going to cry. So I'm not going to cry. Sharon Brown, I'm so glad to see you. Good morning. We're about to see some nonsense. Let me see if she's doing any nonsense yet. Oh, shit.
I believe that was done on the original direct examination. So I'd ask that the redirect be confined to matters that were brought up during the various cross-examinations. So as to this particular question related to this general statute, it seems like we're going back to the very beginning and rehashing his original direct examination, perhaps out of a concern that they didn't do the kind of presentation that the case would have called for initially.
Well, Your Honor, one of the questions that repeatedly came up during cross-examination is whether or not the defendants knew if they were electors or not. This statute spells out if they're electors. So I think it's appropriate to bring up the black letter law on redirect as well as the exhibits that correspond with this black letter law.
Your Honor, if she wants to go specifically into the state of mind of the electors, that's one thing. But to simply rehash what the law is at this point is irrelevant.
I would tend to agree, Your Honor. But when it comes to the black letter law, while I would maintain no defense attorney here has any problems with that being examined, it should be confined really to the most part for what was covered during cross-exam. My cross-exam, I was able to cover the black letter law with him, and he made testimony, or he provided testimony on it. So I think that any redirect should be really confined to his remarks on cross.
Hi, easily. I saw your note from this morning. Good morning. She hasn't even
asked a question yet.
Good morning. Good morning, Sharon. Easily, Lee.
The black letter
all
law
of
that
our
was clearly
viewers
discussed
on
on
Twitter
cross,
and
there was an
Twitch.
objection.
Good morning, and I adore you.
It could be. It could start off. You were asked on cross-examination. We don't even know what the question is yet.
I think that's correct. I'm just supporting this.
Why is that not showing?
Thank you. Let's wait to see what the question is.
Oh, there it is.
Yes.
Sorry.
Now, is it fair to say 1.6842 governs how nominees for electors are appointed in the state of Michigan?
Yes.
And I don't want you to read the document. I just want you to look at Michigan Compiled Law 168.46, which I believe is
I'm sorry, are we talking about 0.42 or 0.46?
I'm moving forward to 168.46. And did you also review that statute, sir?
Yes.
And does that statute govern the certificate of ascertainment?
Yes.
Was there a certificate of ascertainment in this case?
No.
In this case?
Oh, in the case, I thought you were referring to the document. Yes, there was a certificate of ascertainment in this case. Yes.
This investigator sucks balls. I'm sorry. I'm going to say it. I don't care how hard he works.
Your Honor, again, I'm going to
He
object
sucks
that there's
major
no tie-in
balls.
to any of the cross-examination. I'm not sure what we're doing. Are we just going back over the original, or
Maybe she gets to do her questioning, you fat little
It's not
prick.
redirect. I gotta get there.
Sit down, bitch.
We're holding the objection. I noted it.
Thank you.
Certificate of ascertainment.
Okay. Now I'm gonna hand you Exhibit 11. And is that the purported certificate of votes for the Republican nominees for elector?
Yes.
Was that accompanied with a certificate of ascertainment?
No.
Does that certificate of votes match the results as certified by the certificate of ascertainment, which is Exhibit 5?
I'm going to object. This is already issues that she's covered on her direct.
I would agree.
That's the news.
Exhibit 11, pages 2 and 3.
Now I know why I couldn't be a lawyer. I would yell at these fucking douchebag maggot lawyers. I would yell. It would be bad. I would be kicked
during
out.
your investigation, did you obtain any information about an attempt to attempt to deliver or publish that document?
Objection has an answer.
Well, according to redirect, there was no evidence of an attempt to publish. I mean, to cross-examination.
Or attempt to publish by whom? That was
by the electors.
That was okay. Thank you, because that wasn't clear in your original question. Objections overruled.
Thank you.
No, I'm going to object to this calling for a legal conclusion as to whether it was uttered or published. And the reason I say that is because unless this witness has, I would only ask that he be asked specific questions, because whether it's published or not goes to what specific facts.
These motherfucking fuckers are limiting her when they have run roughshod over this fucking hearing. I'm not happy with this judge on this point. I'm tired of it. I'm tired of her being hamstrung by
she has
these
to address it
fucking
because there
whiny
was
white
direct
men.
questions to this witness as to whether or not
I'm not supposed to.
there was evidence.
Sorry.
That
what evidence? I don't have an objection to what evidence of it is there.
I gotta close my window. Hold on.
That's that question. Okay. I withdrew my objection.
Okay, repeat your question.
During your investigation, did you uncover any evidence of either attempts to publish this document or actual
I
publication
can't
of this
yell
document?
because my poor neighbor is like, please don't yell so loud in the morning. And I'm like, I won't, I'm sorry. Good morning, gal. Good morning.
Well, I gotta get to the next question.
All right, if that's where you're going. I was just
Okay, you allow her to ask the question. We can't every 2 words say the objection.
Thank you. Thank you.
Thank you. Now, was there one attempt, multiple attempts to publish this document?
There's multiple.
Okay. I want to start with the first attempt to publish the document. What date was that? And if you can tell us by who?
First attempt was on December 4th, 2020. That was by a group of electors, Republican electors, and there was some other representatives there as well.
And where was the attempt to publish Exhibit 11?
At the Capitol Annex.
And based on your investigation, was that attempted publication, or was that publication successful?
Yes, they attempted to publish it. It was not received.
Judge, objection. He keeps saying they because we have specific uncle or individuals instead of they.
Agreed.
If you can name persons in the group, that would be helpful.
Ian Norton.
Okay.
And so when Ian Norton did what?
Yes, Your Honor.
What did he do?
To publish.
He attempted to publish. And your testimony is that he was successful?
No, he was successful in presenting the document to the state police. But as far as publishing it, it was the attempt to publish was made there at the Capitol.
Judge, I would object to that.
No.
About a envelope,
Stop.
not a document.
That's
Sit down.
Argument really, but the court is aware of what the video shows.
Yeah.
You can proceed.
Now, was there a second attempt to publish the document?
Yeah.
And do you have a date for that?
It was received by the National Archives on January 5th in 2021 in the U.S. Senate.
And just to show you, this is Exhibit 10. Is that the document that was received by the National Archives?
Yes.
Looking at Defense Exhibit A, does that document have contingent language?
Yes.
In your investigation, did you find any evidence that there was an attempt to publish that document?
No.
In fact, during your investigation, were you able to locate a signed copy of that document?
No.
Did you speak to members of the Michigan GOP during your investigation?
Yes.
And were any of the members of the Michigan GOP that you spoke with able to direct you where you could find a signed copy of Defense Exhibit A?
No.
I'll show you Exhibit 6. Can you tell us what that is?
The 2020 certificate of votes for president and vice president, state of Michigan, for the Democratic electors for votes cast for President Joseph Biden and Kamala and Vice President Kamala Harris.
And that document actually corresponds with the results that as they are laid out in the certificate of ascertainment. Is that correct?
Yes.
Is the certificate of votes a public record?
Yes.
During your investigation, were you able to find any evidence that the Republican slate of nominees legitimately could vote or deliver a Republican slate for the Michigan Electoral College?
No.
What evidence did you obtain to the contrary?
The popular vote was approximately 150,000 or 154,000 vote difference between President Joe Biden versus President Donald Trump. The votes had been certified by the Board of Canvassers. The Senate Majority Leader Mike Shirkey and Speaker of the House Lee Chatfield had announced both on November 20th and December 14th that the legislature was not going to interfere with the results that had been certified. And of course, locating this document as well, along with the certificate of ascertainment.
Now, we have heard during your cross-examination about 2 slates being delivered in Hawaii in 1960?
Yes.
Are you aware of the circumstances of 2 slates of electors of votes being submitted from Hawaii in 1960?
Yes.
What were the facts of that?
Well, initially, President.
I'm going to object to.
Unless, I mean, is he reading from Wikipedia? How does he know this?
What's the foundation?
I guess we're doing a joint.
There's 2 different objections. One is
currently a simultaneous.
Yours is lack of personal knowledge. Is that your foundation? Okay. And this is foundation. You can respond.
Did you obtain this information during the course of your investigation?
Yes.
And did you research why 2 slates were submitted for Hawaii in 1960?
Yeah.
Why did you think that was important as part of your investigation to learn about 2 slates being delivered 60 years in the past?
Because it was referenced by the Republican electors of 2020 and many other people, including Mr. Jesco.
Yeah, procedure.
Could
you tell us what information you were able to learn about why 2 slates, why 2 certificates of vote were delivered?
Your Honor, I'm going to object this to the foundation. What's his basis for that? Is it Wikipedia, as Mr. Bellotta suggested? Is it some official record? Is it, what's the basis?
The basis of his understanding of that case?
Yes.
You can ask him how he researched it.
Where were you able to obtain information? Well, first.
Is there another objection?
Yes, I had objected on relevance. The facts of that case have no bearing on the facts of this case.
Oh, well, it's really interesting because you guys keep bringing it up as a fucking defense. So I think maybe you guys are the drama, okay? You're the ones who keep bringing it fucking up.
Does he testifying what?
Unless he's testifying as an expert, the only thing he's testifying about is the facts in this case. The facts in that case are irrelevant.
Did you want to respond?
Well, then you can't bring it up.
On cross, Hawaii 1960, the fact that the Republicans and the Democrats both submitted a certificate of votes was referenced. It was referenced as state of mind for the defendants. I think it's important to know the underlying facts of that case and how they do not mirror the situation that was in the state of Michigan in 2020.
Just want to go on the record, Your Honor, from Ms. Rook and say that we 100% disagree with the defense objection. By Mr. Gilbert, we believe that 1960 facts are very relevant because it was motivating a lot of these attorneys to do what they did.
We have a number of co-counsels that are not present, but from the first iteration that would agree with you.
I just wanted to join that objection.
I agree with Mr. Bellotta.
Objections based on, unless this witness has some evidence that his understanding of what happened. I mean, what happened in Hawaii.
Okay, so they get to bring in Hawaii, but the defense or the prosecution doesn't get to explain Hawaii. You're kidding me. Get this. They want to bring in the Hawaii situation, under which there was a formal recount, and it was acknowledged that they were going to do 2 slates of electors, so because the recount was active and underway. There was no recount in Michigan at the time.
Well, I don't know what her question to him as it relates to that. Those 2 situations actually don't
line up. The defense is using it as state of mind.
Or what his understanding of the case was, and
they're not allowing actual facts of that case into the conversation. That's a problem.
Complaint. But that would have presented a follow-up question for me.
You don't get a one-sided narrative.
What his answer was anyways, just because I recognize that he may have read or reviewed that case. I don't know how he could make a conclusion as to whether or not those facts.
That makes sense. I understand, Kathy. He is not an expert.
That costs for legal,
etc. I do understand that.
Right. Your Honor, I should clarify. I have no objection in that context, as Your Honor was just saying, for his investigation, that sort of thing. But if the attempt here is to try to, put that over that to my client, that somehow that was his state of mind, that's where I'm
right. But I'm thinking she's doing this so how it affected his
right, and I have
investigation,
and I've got no problem with that.
I'm allowing, but if it went into that, what you're talking about my concern, it would cause a follow-up question.
And I'm not asking this witness to make a legal conclusion. I'm just trying to elicit the facts that were the underlying facts of why two certificates of vote were submitted in Hawaii. And I mean, I think based on the days of testimony, the court's well aware of the facts in this case and how they could be distinguished from Hawaii 1960.
Okay. Your objection is overruled.
Your Honor, my objection was one of that Agent Shock's understanding is totally irrelevant. What's relevant, unless we're talking specifically about the investigation, but
so everybody's feelings are irrelevant, and no facts can come in about the case.
Ability to show
Your Honor,
what the electors understood that Hawaii situation, and that so I think it's important to note that it's irrelevant for that purpose. What Agent Shock believed.
I would agree. It wouldn't. It doesn't have any bearing on what the elector's mindset was, because he can't speculate as to what their mindset or understanding of the case was. So I agree to that, but he can still respond as to
the
how
fact, as he understands
affected his
them.
mindset, which steered his investigation.
I think, and maybe I'm wrong, I think what the prosecutor was trying to do is just explain why this didn't deter him, that he knew about Hawaii and he kept going. And that's the purpose.
I think that's what she's trying to do.
I have no problem.
I think
I'm trying.
You can proceed, counsel.
Please proceed, sir.
So, like I said, it was Mr. Chesbrough had brought it up. Mr. Northen had brought it up when he was there at the Capitol trying to publish the documents. So, going back to 1960, well, what I learned about it was from a variety of sources. So, the open source information through whether it was news articles or there's I looked at there's Stanford, Cornell Law has information about that, so turning to those sources as well. Looking at what took place, and then
he should just say these are the facts of 1960 as I understand them from my investigation.
Those articles, and learning that the President Nixon had received initially the popular vote. The vote was too close to call. There was a court-ordered recount that was put in place. President Kennedy ended up winning the state of Hawaii by 115 votes. And one other thing, the electors met
just
together,
hear it.
And they both cast their votes together because the election was too close to call. And so there was, they wanted to have both slates ready to go in case during the recount, President Nixon's votes were superseded by President Kennedy.
So if I'm understanding you correctly, there was a legitimate controversy as to the final results in Hawaii.
Yeah.
Legitimate controversy, an active, coordinated public effort to submit the two slates in order to cover how the recount would come out. So very, very, very different from Michigan 2020.
For the election results? I'm sorry.
No.
And what evidence did you obtain to show that there was no controversy as to the Michigan presidential election results?
The fact that the vote margin was 154,000 votes. The Board of Canvassers had met and certified the votes. The legislature had stepped in and said, both on December 14th and prior to December 14th, that this legislature was not taking any action. I didn't uncover any
because there was no action to take
ruling at that particular time that was going to overturn the election, or no court had stepped in and said it's too close to call, like we're talking about in Hawaii. It would be beneficial to have both electors vote at the same time.
Your Honor, I'm going to also object that unless you can tie that to the state of mind of the electors, that whole answer is completely.
I'm sorry. The facts need to come in. Sit down, Pudgy.
Their intent or state of mind. It's only relevant as to why he did his investigation.
Thank you.
I meant to say pudding, but I said pudgy. I apologize. Sit down, pudding.
Now, based
That's his
on
name from now on.
This information that you obtained during your investigation, was that the basis for you drafting your complaint?
Yeah.
Now, there was a lot of talk during cross-examination about evidence and information that was obtained after you drafted your complaint.
Yes.
Interviews that were conducted after you drafted your complaint, specifically with Mr. Renner and Mr. Chesbro. Do you recall those many questions?
Yes.
And actually, Mr. Chesbro provided several emails that were around the time of the election. Is that correct?
Yes.
Did you review those emails?
Yes.
Did you make any attempts to do independent investigation based on the information contained within those emails?
Yes.
What did you do, sir?
Try to verify the information and talking to other states and following up on the social media posts, drafting additional search warrants.
And as it related to drafting additional search warrants, were you able to obtain information from 2.5 years ago based on, I guess, probable cause generated by those Chesbro emails?
Yeah.
What kind of information were you able to obtain?
Just the social media accounts of Mr. Chesbro, conversations that he had.
His hidden. Remember Kenny Chesbro's hidden Twitter account?
Members of the Republican National Party, their campaign for President Trump.
And did you review that evidence?
Yeah.
And just talking about the subsequent interviews and then subsequent evidence that you obtained after your complaint, would that have changed your decision to draft a complaint in this case?
No.
Why not?
Because there was a concerted effort to create a slate of electors to present to Vice President Pence to cause a pause in the election or the counting of the votes.
And I'm going to hand you Defense Exhibits D and E. You recognize those?
Yes.
And on cross-exam, you were asked to read several statements indicating the state of mind of several electors on the day of December 14th, 2020. Do you remember that?
Yes.
You were also asked if those statements would change your mind about whether or not those electors had an intent to defraud. Do you remember that question?
Yes.
Your Honor, I'm going to ask for clarification of what specific electors she's referring to instead of those electors.
Can you clarify? I can. Who are the authors of those statements in Exhibits D and E?
Michonne Maddock and Amy Facinello.
And do you remember on cross-examination saying that those specific statements in D and E would not have changed your mind about the defendant's intent?
Yes.
Could you explain to the court why those particular statements in D and E do not change your mind?
Your Honor, I'm going to object as to the relevance as to Marianne Sheridan's state of mind.
Well, I didn't say it went to Marianne Sheridan's state of mind.
Well, so the defendant's intent.
The declarants.
I would join the objection also.
She's changing it to declarants intent.
And
to what?
To the declarants.
These exhibits were admitted on cross-examination over the people's objection as to state of mind of the defendants, and I'm allowed to go into.
He was objecting as to his client for that, is what he said.
That's fine.
You change it to declarant. versus defendant.
So the objection sustained.
As to your client, yes.
Yes, I'm specifically, well, I believe these were admitted by Mr. Bellotta. So
I appreciate the detailed
fairness,
back and forth because I know it has to happen.
The purpose that Mr. Bellotta,
but it's so frustrating.
And that's what my redirect is going towards.
Thank you. If there was a question, I'm sure he doesn't remember what it is.
Yeah, I mean,
was gonna ask.
On cross-examination, you were asked if these statements by Ms. Maddock and Ms. Facinello would change your mind as to these defendants' state of mind or intent. Do you remember that line of question?
Your Honor, I'm going to object it to its entirety because they're not even defendants in this particular proceeding.
Well, it was admitted over my objection.
She's addressing something Mr. Bellotta admitted. So she has the right to address it because he addressed it on his cross.
Okay, I don't remember my question again. Do you remember my question?
I do.
Okay.
So you had asked me based on reviewing this.
They're just trying to trip her up. That's all they're doing. That's all this is.
Why?
Yes.
That didn't change my mind. As it references in here, we need additional time as more evidence develops. It's our duty to the people of the state of Michigan. We voted. We weren't allowed into the Capitol. There's some other language in here that criticizes people, but the point is that the votes were certified by the Board of Canvassers. The vote margin was 154,000 votes. The state legislature had said on at least 2 occasions that they weren't going to interfere. They were going to allow the electoral process to play.
I'm sorry, I'm going to object to on 2 occasions, because one of those occasions happened after these people signed this document. I think he's referring to the November 20th release of the statement by Mr. Sherky. Is that correct?
Yes, sir.
I would just limit it to the one, not 2. Thank you.
What's the objection?
The objection is that he's misstating the evidence in the record, which is that there were 2 statements out there with these folks signed. That's what he's implying the answer. So that was my objection. It states evidence in the record.
Do you want to respond to the objection?
Well, I was asking why these statements would not have changed his
I wasn't objecting.
No, he's objecting to the response.
Okay.
So the objection is sustained as to the response. Did he answer your question?
Were you done?
No, but so there was one statement by the Senate Majority Leader and the Speaker of the House said that they weren't going to interject or change the electoral votes.
Do you remember when that was?
November 20th, 2020.
Okay. Now, in reviewing the social media returns, did you come across a conversation between those 2 electors, Maddock and Facinello?
Yes.
And did that also affect your determination whether or not the comments in D and E would have changed your mind as to those defendants' state of mind?
When you say those defendants, it's just those 2 and that.
The declarants in D and E. They're the only ones who make comments in D and E.
Your Honor, again, I'm going to object to the relevance as it relates to this group of.
This is bullshit. I'm sorry. This is bullshit. I can't.
Mr. Bellatta's
They're just trying to throw her off.
exam.
It doesn't make
This
it
is fucking.
relevant.
Strategy is one thing, and that's fine. But this is bullshit. There's not a fucking jury there. Stop performing like a monkey. Good morning, Oomph. How are you?
Did it change my state of mind?
I'm gonna just try and ask the question again.
Okay.
The 2 electors that are the focal points of the comments in D and E, John Maddock, Amy Facinello. In reviewing their social media returns, did you come across a conversation between those 2 defendants?
Yes.
And on cross, you were asked if the statements in D and E changed your thoughts as to those defendants' state of mind or their intent. What I am asking is the conversation between Ms. Facinello and Ms. Maddox that's in the social media return. Did you also take that into consideration when determining those defendants' state of mind and or their intent?
Yes.
And how did the conversation specifically between Ms. Maddox and Ms. Facinello in comparison to the statements in D and E affect how you view their state of mind?
They're contradicted.
Do you recall the nature of the conversation between Ms. Facinello and Ms. Maddox in the social media return?
Yes.
And what was it?
They said we're not electors.
Do you recall when that conversation occurred?
Can we have an exact, instead of him just spitballing what he thinks they said, I'd like to know the exact words mean so much in space. That's what going to intent, but okay. And have him ask that he read the word. Thank you.
Please clarify and direct him to where the exhibit these words are used.
I will. Do you recall the date of that conversation?
I don't. I'd have to look at the material.
Would that refresh your memory to the date as well as the actual language in the conversation?
Yes. Thousands of pages of material.
I'm going to hand you what has been marked for purposes of identification, People's Proposed Exhibit 28. Could you tell us what that is?
It's the certificate of authenticity for records from Meta, and then the business records as well.
And on the second page, does it identify who that particular return belonged to?
Yes.
Okay, and who did it belong to?
Amy Facinello.
I'm going to ask you to turn to the 5th page. In the upper right-hand corner, I believe the Meta page number is 23,150.
Okay.
Do you see a highlighted conversation at the bottom of that page?
Yes.
Could you read that to yourself, sir?
Okay.
This prosecutor is doing a really good job. I really am so grateful.
A date and timestamp.
She's got a lot to
the
handle.
Date and timestamp.
Starts out 2020, December 5th. Timestamp 20 hours, 58 minutes, 39 seconds, UTC time, and that's military time.
And does that thread indicate who the participants are in that conversation?
Yes.
And who are the participants?
Amy Facinello and Michonne Maddox.
Who is the first person in, I guess, to make a comment in that conversation?
Amy Facinello.
What's that comment from Ms. Facinello?
Have you received any communication about being an elector? ? I have not gotten even a letter or a single phone call, period. I have zero idea what is happening, period.
And again, I'm sorry, what was the date and time of that post?
That was December 5th, 2020 at 20:58 hours.
And is there a response to that question?
Somebody was having a little drinky.
Who responds to that
Got
question?
on social media.
Michonne Maddox.
And what's the date and time of that response?
December 6th, 2020. Time is 01:22 hours, 40 seconds UTC time.
And what's the response?
We are no longer electors, unfortunately.
Is there an additional response?
Yes.
Who sends that?
Michonne Maddox.
What's the date and time?
December 6th, 2020, 1:22 hours, 54 seconds UTC time.
And what's the response?
Only if the president had won Michigan.
Sorry, can we get a date on that last one here?
Oops.
Yes, December 6th, 2020. Time is 01:22 hours, 54 seconds.
Thank you.
Welcome.
Good morning, peace, love. How are you?
None of the people conclude our redirect.
I have
I'll take all of these.
Your Honor, I'm sorry.
I have a couple questions. Agent Chalk, you testified shortly.
Good morning, Badger, Badger.
That at the time that
long
the
day at work. Oh, sorry to hear that, peace, love. Good morning, Robert.
14th,
I'm sorry to hear that, peace, love. I hope the day goes fast.
Controversy that existed in 2020. Were there at the time no legal proceedings relevant to the election pending at that time?
Yes.
There were or no?
Yes.
There were some?
Yes.
Okay, so how did you make a determination that there was a legitimate controversy if there were legal proceedings at the time?
There's nothing, again, we had the certification of the votes by the Board of Canvassers. The margin was so wide, there was no court order recount. State legislature had not intervened. And while there was pending litigation, there was nothing that I saw that was going to immediately have an effect on that decision.
What kind of cases were pending relevant to the litigation of the election?
They were court cases about the summarize here, just voter irregularity.
Okay, so wouldn't the question of there being a legitimate controversy be a question for a court to decide and not for the agent who's investigating this to decide?
Yes.
But you made the decision and not the court that there was a legitimate controversy?
No, the court made the decision after I took over the investigation.
Okay, so they made it after December 14th? Because my question was there a controversy tied up in the court on December 14th when this alternate document was signed?
Yes, ma'am.
Okay, and so how does that play into your statement that there was no legitimate controversy at the time that the electors knew of?
Good morning.
Like I said, in my mind, there was nothing that was going to take place. There had been several court cases leading up to that, all of which had been dismissed. And there was nothing that I was looking at in these court cases. You know, again, I'm reviewing it 2 years later.
He has access. I don't know if he has access to Ken Cheesebro's social media, but
what was happening at that time on December 14th?
I just
there
wonder
were
if
cases still tied up in court about the election.
I think there was one appeal or something.
At that time, it's reasonable to believe that the Republican electors knew about those cases that were pending, correct?
Yes.
How do you determine now that at that time, even though these cases were pending, that the electors knew that those were not legitimate controversies?
I didn't see anything that there was going to be a recount put in place, that there was going to be an action by the court to overturn the election. So I saw what I did see was
69 viewers,
decisions about voter irregularities and things like that, but I didn't see anything that is going to ultimately change the outcome of
54 on Twitter.
The election here in Michigan.
And you saw that on December 14th, or you're saying that those decisions that came after December 14th?
No, I saw that on December 14th.
Okay, so everything that was still pending that you saw on December 14th would not have had an effect on the ultimate outcome of the 2020 election.
The ultimate outcome, yes.
Okay, and then my next question is that you stated that you chose to author the affidavit in support of these complaints because there was a concerted effort to present a slate to cause a pause in the electoral process. How was that a crime?
That's to cause a pause in the electoral process, federal crime, that would have an impact federally. If presidents—
How's that a state crime?
I was going to get to that. So there was information I learned in the
this is
investigation.
just the judge
that
making a decision on
second slate of
whether it
electors
goes to
was
trial.
created to put pressure on the state legislature to change or to have an impact on the counting of the votes or the certification of the votes to intervene in the state election.
And your perception based on your investigation was to have the legislature intervene in a fraudulent way?
No. To stop or change the election or the counting of the votes here in Michigan.
I understand that, but you're saying you want them to stop or you thought that the effort was to get them to stop or change it in a way that was fraudulent?
No.
Okay, so then how is electors, or let's not even call them electors, how is it that citizens taking effort to cause their legislators to pause a process a crime?
Well, anything that would interfere with the state law that lays out the electoral process, any violation of that would be the crime. If we have the electoral process laid out in statute, and maybe it's the state legislature or somebody else that changes that or tries to circumvent
hearing
that,
in about 10 minutes.
That would be a crime.
A crime of what?
The crime of the election law.
Okay. And then my last two questions is why, because you said that it was Ian Norton, you said his name was, that attempted to present or publish the document on December 14th. Why has he not been charged? Or do you know?
I can't answer that question.
Okay.
I'm gathering facts, and it's an ongoing investigation.
I've heard that. But we're not. You don't believe you have enough facts gathered for Ian Norton, even though you testified that he was the one who tried to publish the document?
Yes, there's further investigation that's needed, Your Honor.
Okay. And Chesborough, I think there was a whole docket, or I should say file of exhibits as to statements that you were provided by him and you met with him, correct?
Yeah.
You don't think you have enough evidence to charge him?
I've got it teed up in the other window, so I'll go to it when it's live.
Okay.
So
we have 75 total viewers, 16 here on YouTube
gather
and Twitch,
more information,
and the rest of them
information
count
that's outside that proper, because we can't use the information that was gathered in the proper against him.
Correct.
And it's become challenging with all the media attention, and every advancement in my investigation becomes public knowledge now.
But as to, can you use the ongoing investigation to explain why you believe Mr. Norton has not been charged? However, you have video evidence that he was the one who allegedly tried to publish it, correct?
Yeah.
I mean, I have the same question.
You don't have any evidence that the named defendants in this case ever had the document in their hand to try to publish?
Yes.
Okay. Any additional redirect or
Jenny wants to
process?
stay out of prison really
Yes,
bad.
to your last question, you mean correct?
Correct. Yes. Correct.
I just had one clarifying based on the first question. I'd like to know what crime he's referring to, as far as if someone doesn't follow what the Michigan statute.
He said it was a violation of the election law.
Where is that in the crime or criminal statute?
He can answer that if he can.
Is there a criminal statute that says it's a crime and lots of prison time to someone who doesn't?
Do they not know the charge? What are the charges against the defendants? I have to look at their indictments.
What's election law? But that's forgery, though, correct? That would require the elements of forgery, right?
Yes.
Okay.
Thank you. You had a question?
Well, I guess I thought I was gonna go first, but I'd rather all the
that's fine
before I go.
Before you redirect should be last.
Yeah.
Any recross based on my questions?
Yes, briefly. Oh, based on your question?
Yes, my question.
Sorry.
The answer is no, Your Honor.
You mean the claim in response to the judge's question that you think that you acknowledge that there are cases pending that were challenging.
There was one appeal, I think. Let's be specific.
The outcome, that any result in these pending cases could change the outcome of the election because it had already been certified.
Yeah.
And you don't believe that a judge, that a court in Michigan could have the authority to order certification for a different candidate?
No, they could.
Okay, so then you understand that one or more of these pending lawsuits that were still pending on December 14, 2020 could have resulted in a court ordering that result to be certified for President Trump, correct?
No, I don't think so. Wait, could we be specific about what was outstanding in Michigan as of December 14th?
Thank you.
I'd like that to come into the record, please.
Mr. Villato's question. So essentially, you just ignored those other cases that you just felt you knew what the courts were going to do.
I love MAGA lawyers and their focus on the feelings. I really do. I appreciate it. It's a cheap trick, but I love it.
Okay. And then testimony came out, I think it was yesterday, that Ian Northup, based on the video, was not representing any of the defendant electors, right?
Yes, that's what he said.
Okay. So did Hank Choate attempt to hand an envelope to anybody on December 14th at the state capitol annex?
No.
Okay. Did any of the other electors try to hand anything to in an envelope or any paperwork at all to the police at the state capitol building on December 14th?
Did anyone?
Yeah, did any defendant electors?
Oh, defendant. Oh, no.
Okay. So you're attributing Mr. Northump's actions when he was not representing my client and the other electors. You're attributing his action to them, right? To say they tried to publish. That's what you're saying.
Yeah.
Okay. How was that possible if you didn't represent him?
Because the initial approach to the Capitol Annex and state police was that they were all there together. We are electors.
Judge, I'm going to object to that. That's a mischaracterization when he says they were all there together. There were certain individuals who were there, but not all my clients.
Yes.
Objections sustained.
So the mere fact that they were there means they tried to publish it?
Well, I would ask
because they were there.
Barring the objection for clarification that the witness be allowed to finish his answer, he was mid-sentence.
I thought he was done.
We can continue.
That's fine.
I think, yes. This is a representative there, Rendon, was there telling the state trooper, followed by Mrs. Maddock, and some of the other select defendants were there, telling them that they wanted to gain entry to the Capitol to serve the electoral votes.
Can you repeat the representative's name you said?
Dare Rendon.
Dare?
Dare.
Can you spell it?
D-A-I-R-E. Rendon.
But again, they didn't gain entrance to the Capitol, right?
That's correct, sir.
And they never left any paperwork at the Capitol, right?
So really,
Yes.
again,
So
if a tree falls in the
published,
forest
so that
and
they never
nobody
got
sees it, did
right?
it fall?
Yeah.
Okay. Yeah. And then you said in response to Judge Simmons' question, wouldn't a court decide if it's a legitimate controversy? And isn't it reasonable that the electors knew of the cases, and you acknowledge that?
Yeah,
that's true. But then you gave your litany again of that you're relying on the fact that at that point on December 14th,
DOJ to charge.
Right? That there had been no legislative action.
I wonder if we'll hear about that today.
Yeah.
And the Board of Canvassers had acted, right?
Yeah.
Okay. Well, let me ask you about the legislative action. You keep referring to that. This Shirky Chatfield press release as if it's some kind of legislative action. That was not legislative action, was it?
No.
Okay. The legislature speaks as a whole, right? As a body when they vote, right?
Yes, sir.
Okay. So Representative Chatfield and Senator Shirky had no authority to issue anything or bind the whole legislature with a press release, did they?
They were speaking on behalf.
No, they were speaking on their behalf.
Thank you. I
I
appreciate the heads up.
I'm sorry.
Yes.
Okay. So they were not speaking for the legislature as a whole, right?
Yeah.
Okay. So why is it unreasonable then for the electors to think, because they had 5 legislators apparently with them at the Capitol building on December 14th, that there might be some legislative action? Why is that unreasonable?
You hit it.
Then think that.
You hit it.
I don't know.
Well,
that's
it is
kind of the
reasonable,
point, isn't it?
I don't know what they were thinking at that time.
Okay.
Has a couple of juicy paragraphs, but not a whole lot of information expecting more or expecting Gal to construe the dates.
Yes.
Excellent. Yeah, I know. I'm sure there's some filling in of the gaps as we speak.
Redirect.
I was going to try and do this in reverse order, but that's not going to happen. Specifically with exhibits 10 and 11, which is the certificate of votes that was executed by the Republican nominees for elector. During your investigation, did you find any evidence that there was an expectation of state legislative action with regards to the Republican certificate of votes? No?
How does that go to any of my questions?
Well, you asked about the criminal activity, and not because the witness is understanding, and I don't want to be seen as.
You're talking about my question where I asked him about his response that there was a concerted effort to present a slate to pause, and I asked him, how is that a crime?
Like more indictments are to come. Or a superseding one, or both. Yes. It described one scheme.
Okay, because that was way off
I
from
kind
what
of
my
want to read it.
question
I
was.
won't read it online, but I kind of want to read it.
If I wrote down verbatim his statement. I want him to explain to me how that was the crime. Because that's why he authored the affidavit, is what he said.
I'll take the direct route. According to Michigan law, only the appointed electors can deliver Michigan's electoral votes. Is that correct?
Yeah.
And according to the certificate of ascertainment, which party's electors were appointed?
The Democratic elected.
And did they author a certificate of votes for the 2020 electoral votes for Michigan?
I'm going to object. I don't see how that follows through with what the court authored.
It's building up to it, maybe?
Okay.
It's a fact. Dawn.
Now, also in 2020 was a certificate of votes created by the Republican Party.
Sorry.
Yes.
And was there a certificate of ascertainment granting the Republican Party the authority to create a certificate of votes?
Objection, Your Honor. Asked and answered. I know that she's trying in order to get somewhere, but frankly, we already know this. We've heard it many different times. Republicans did not have a certificate of ascertainment.
Maybe it's a start.
I completely agree.
I'm getting to
I just want to know what was the violation of law based on his statement from your question, was that he moved forward with authorizing the complaint because there was a concerted effort to present a slate that would cause a pause in the electoral process. That was his statement. How is that a crime? What crime did they violate by causing a pause, if that's what they did?
Well, it all is predicated on the execution of this document, and then that leads to one, that is a crime in and of itself, but then it leads to the other.
Causing the pause was my specific question. How was causing the pause a violation? I didn't ask how.
Isn't it because
certificate of ascertainment that wasn't accompanied? I didn't ask for all of that.
Can't you say that the activity is
causing the
to
pause?
Affect fraud?
Okay.
Isn't that to affect
we already
fraud
know,
because those aren't the results
10 times.
of
we
the
already
election?
Know that. I wanted to know how his statement, because they caused a pause, was that was the violation.
I mean,
or a crime.
I don't know.
How is
I mean, I think they should say what the code is. I don't.
Yeah.
I think that's an excellent question by the judge, right?
The certificate of votes that was created by the Republican slate.
Yes.
Feel free.
Was that a legitimate document?
No.
And in trying to serve.
Which document? They don't clear what document you're talking about.
Republicans' certificate of votes. Okay. And in trying to serve that document, when you talk about a pause, can you be more specific as to what you mean?
So it would be a disruption in the counting of the votes, the Democratic slate of votes, the election law process as it is spelled out both in state law and federal law.
Was there an effort to have the Republican certificate of votes accepted over the Democrat certificate of votes?
Yes.
And is that what you mean by the pause and disruption?
Yes.
Objection leading.
Did you want to respond to the objection because your questions were leading?
Isn't there a point at which they can lead? I thought that was allowed in some.
Well, the objection is sustained. The issue I have with the leading as it relates is because I followed up with my question with asking him specifically, was it his position that they were trying to get them to pause for a fraudulent purpose? And he said no.
I think that's wrong. His answer is incorrect.
To that question.
And my follow-up to your follow-up was
to lead him into saying something different, which
yes
would impeach his other statement.
I'm allowed to impeach my own witness.
Yeah, agreed. That's fine. He can impeach away. That just discredits him further and further.
Okay, can we just stop with this and go back? Oh my God. I think the task here is to prove that their state of mind was that they knew this was
as it relates to the last
a fraudulent act, a forgery.
Well, your leading question.
My last question.
He said there was an objection was leading. I sustained the objection.
Well, I can't remember what my last question was.
Your questions about him. Was there an effort for them to accept the Republican slate over the Democratic slate?
That was the second to last question.
Yeah, and then there was
no objection.
There was correct. There was only objections.
To my last question.
He was objecting to your last question. I don't remember exactly which one was the last one.
Yeah, me neither. So the one about the concerted effort to replace the slates was not objected to.
Okay.
And was that accepted by the court?
Correct.
Thank you. We'll have no further redirect.
Thank you. You may be excused from the stand.
I do have a matter, not any questions, but since the focus was Ms. Sheridan is on her state of mind, I'm going to ask that all of the testimony during this witness's examination related to defendants exhibits D and E. I'd ask that all the testimony as it relates to Ms. Sheridan be stricken from the record as it relates to Ms. Sheridan because it's totally irrelevant.
I mean, I appreciate
that
it.
Was I would try. I don't have the exhibits. That was the exhibit that Mr. Bellata addressed Miss Maddock and Fashionella, I believe.
That's correct.
I think we already noted that.
I think that's the art in it, right? It's kind of artful if you think about it.
I'm making, I guess, a formal motion to strike that testimony as it relates to my client.
It has no effect, and that's noted. It's not. It will be stricken as it relates to Ms. Sheridan. Right. I don't believe that it was coming in as it relates to you. He was crossing for his client.
I just want to make that crystal clear for the record.
When you cross for your client, it doesn't come in for his client. It comes in for yours.
Okay.
I make the same objection for my client as well.
Well, right. Your Honor.
I'm assuming
it's not an objection. It was actually a motion to strike.
Okay.
Yeah.
Oh. Her questions was, or her questions when she would redirect was strictly, and she changed it to say as it relates to the declarant anyways to make it clear. But Mr. Bellata wasn't or isn't able to admit that to show or defend your client's state of mind. He only was bringing it in.
Yeah, and for the record, the reason that I brought it in, I said it at the time, was there were claims that these people had it wasn't contingency, and that they had they knew there was no legal reason to sign these documents. And I think that
right. It was.
That's why I brought it in. I wasn't, and it's of course not a statement of any of our clients.
Understandable. Counsel.
Well, one, I think we all agree that the rules of evidence are very clear, and I was just redirecting on evidence that was admitted over my objection during cross. I cannot say before this court whether or not any other defendant referenced those exhibits during their cross, but to the extent that they did that evidence, and my redirect should be used against them. So I think it's premature just to do a blanket motion to strike for every defendant except Rose Rowe.
Okay, well, I'm quite confident he didn't bring that exhibit up.
Yeah, I know Mr. Freeman did not.
Yeah, I can't recall anybody other Mr. Bellata bringing it up. I think he's the one who had it admitted. The record is there, so we'll know who it should be stricken as to and who it shouldn't be. And if they brought it up, it won't be stricken as to their client, but my recollection is only Mr. Bellata referenced it.
And also to the extent that we're talking about the things that were and were not considered the quality of Agent Shock's investigation, it does go to his state of mind. So to a certain extent, it's still admissible for those purposes, not as hearsay against the defendants and not as to the defendant's state of mind, but statements that the agent took into consideration when either investigating further or, you know, how he interpreted evidence. But again, it's not going to be used to establish the state of mind for anyone other than the declarant.
Is that an objection?
No, I think she's clarifying she's clarifying why she used it or referenced it.
Looks like we might hop soon.
She was
so
using
be
it.
ready.
I think she said this on the original objection you made while she was questioning him, is that to show why he took the direction he took.
We're still talking about D&E.
D&E in his investigation, not about anybody's intent or their state of mind.
I missed it. We were still talking about D&E.
We're still talking about D&E.
I was done with D&E.
I know you were.
Thank
you. Okay, sounds good. So you have another witness that
I do.
Okay, well, we're gonna give everybody a 13-minute break because I like round numbers. And so you guys can come back at 10:20. And then which witness will we be calling?
Jonathan Brader.
Sounds good. Off the record.
We'll go ahead and silence that. We will also, I'll keep an eye on that and we'll stop that at the break as well. Making it smaller, making it smaller. Hey, making it smaller. Making it smaller. Okay, now let's make these guys bigger. We're going to do that. We're going to do that. Oh my God. Okay. Little tiny baby window. Whoopsie poopsie. We're going to put you right down here. Okay. And then we're going to make the Jimmy Jordan window bigger for the Jimmy Jordan. Whoops, shit. Okay. I gotta concentrate. Sorry. Hold on. I don't know how to use my hands anymore. I can't use my hands. I can't use my hand. Oh, fuck in the fucking. That's different. Oh, mother. Okay, I'm concentrating. Nobody talk to me. Nobody talk to me. Do not. Oh, my frickin' frackin'. There we go. Sorry, that window has always been just a little bit funky. Funky monkey. Here we go. I want to do that, and I'm just very concentrating. I'm concentrating so hard. She's concentrating so hard. Okay. All right, come on. Get your shit together. Okay. Oh, no. Close. Okay, I think my tax dollars could go to closed captions, okay? I think they could pay for some closed captions on the official YouTube channel of the judiciary. Okay? Is that too much to ask? Is that too much to ask? I don't even understand that. I don't even get it. Okay. Well, they're having an issue. I bet you it's on something else, isn't it? God damn it. It's fuck my life. Okay, hold on. I'll try and figure it out. I am very pro closed caption. It is ableist to not do that, and all government communication tools should have all the ADA. Exactly. I think that's a great idea. Oomph. I think I will do that. I will start bugging the U.S. government, the White House, whoever will listen, whoever's in charge of making sure, or the Congress, maybe the whatever's, Mike's Little Johnson. We should make complaints about the fact that there is not closed captioning available on certain government. I'll come up with, some examples of ones that definitely are the official committee YouTube channel. It's on, it's on C-SPAN. Okay, hold on. I don't like you, C-SPAN. I don't like you. I'm not putting your sound on either for your stupid ad. I'm not putting the sound on for your stupid ad, okay, Blanche? I'm just not doing it. Boy, that's the slowest second.
Stanley Woodward, if your guy flips, if your client changes, it could help your chances for that judgeship you are interested in. Unbelievable.
No.
And of course, there's the fact that Jack Smith changed the sequence of the documents he seized in the raid of the president's home.
Sorry.
Had to file this with the judge and with the court. The physical documents don't match the scanned documents. Many people call this tampering with evidence. Jack Smith mishandled the very documents he charged President Trump with mishandling. Remember what Special Counsel Hur found? On page 1 of his report, he said this: President Biden knowingly kept classified information. President Biden knowingly disclosed classified information. And then on page 231, he told us why President Biden did it. Page 231, quote, Joe Biden had strong motivations for ignoring the procedures for classified information because he was writing a book for which he got paid $8 million. President Trump gets charged for allegedly mishandling documents, but Jack Smith can mishandle documents? No problem.
Thank you, Sharon. Universal Design for Learning, UDL. Thank you.
No problem.
If you don't tell
Never
the
forget, this is the same Department
if you
of
don't
Justice
tell the cough is a
made David
what?
Weiss the special counsel in the Hunter Biden case. After Mr. Weiss spent
I think I know what you're referring to easily. The fact that he ignored alleged sexual abuse at his college wrestling team.
He gets named special counsel. This is the same Department of Justice whose Civil Rights Division has done nothing to address the attacks on Jewish students at college campuses. This is the same Department of Justice who can't tell us who planted the pipe bombs on January 6th, who leaked the Dobbs draft opinion, and who put cocaine in the White House. And this is the same Department of Justice who told us in a memo from the Attorney General himself
Fuck yeah, gal.
that moms and dads at school board meetings should be investigated. Same Department of Justice who said pro-life Catholics are extremists. The same Department of Justice who censored Americans.
Merrick's like, I'm so
same
done.
Department of Justice who retaliated against whistleblowers who came to this committee and told us about these wrongdoings. So, Mr. Garland, we're glad you're here today. We've got lots of questions. Many Americans believe there's now a double standard in our justice system. They believe that because there is. And we're going to have lots of questions about that problem.
Anybody?
With that,
where's just the tip? The Wisconsin statute, the charges are being filed under. Check out that link for the Wisconsin charges just filed.
Of course, have had our political disagreements in the past 30 years. But ultimately in this committee, we have worked together, more often than not across the aisle, to pass transformative pieces of legislation intended to help the American people. Legislation to protect women from domestic violence and sexual harassment. Legislation to prevent discrimination against the LGBTQ+ community. Legislation to fight racial discrimination and hate crimes. Legislation to protect Americans' privacy. I am proud of that record of success and proud of how much work of substance we have accomplished in this hearing room under the leadership of chairmen
I thought there was something on my screen. It's his fucking microphone cover.
House that much more frustrating. I've been a member of this committee for more than 30 years, and our work came to a dead stop when the MAGA Republicans took over the House,
Media
and Chairman
literacy.
Jordan took the gavel of this committee. Don't just take my word for it. My Republican colleagues have said it best.
I know.
Representative Biggs said, quote, "We have nothing. In my opinion, we have nothing to go out there and campaign on. It's embarrassing," close quote. Representative Roy said, quote, "I want my Republican colleagues to give me one thing, one, that I can go campaign on and say we did. One. Anybody sitting in the complex, you want to come down to the floor and come explain to me one material, meaningful, significant thing the Republican majority has done," close quote. I agree wholeheartedly. This committee, once an agent of momentum to move our country forward, has become little more than a field office for the Trump campaign. The Republicans on this committee have spent $20 million taxpayer dollars working to get Trump reelected. $20 million on an impeachment inquiry based on statements from a witness who turned out to have ties to Russian intelligence. $20 million attacking researchers who study disinformation and social media companies who are trying to stop disinformation, all in an effort to ensure that Russia can do whatever it wants to interfere in the November election. $20 million attacking the work that the Justice Department and FBI are doing to keep Americans safe. To be clear, this $20 million effort seems nowhere close to satisfying MAGA extremists. They want even more money and resources wasted on chasing conspiracy theories in defense of Donald Trump.
Hi, Siegfried.
Here's just a sampling of what MAGA leaders had to say over the past few days.
Jim Jordan, it's not enough to put out a little tweet, "I'm demanding this." No, where are the subpoenas? Where's the vote? That's what the American people want. What they're tired of is the gutless, feckless whining of the Republican establishment.
I think Jim Jordan and his weaponization committee, his little cucky weaponization committee, should
wait,
issue
you
subpoenas
just wait, Mike
right
Davis.
now.
Jim Jordan, we don't need another performative hearing.
They talk about standing behind Donald J. Trump.
It's Cashy, but down. It's the wizard. Look at me, I'm a wizard. Look at me, I'm a wizard.
I'm sick and tired of strongly worded letters, and I'm sick and tired of them going on Fox
I got
and taking
many
hits and then
pens.
linking
Look at
to
my
it to
3
the page
pens.
and raising money on
Look
the
at my 3
carcass of Donald Trump.
pens.
They don't really have Trump's back. They
Oh my
want
God,
MAGA
I'm
to go
even
away.
bigger. I'm a
Continue
tick.
pushing and forcing these members
I
to
am
actually
a
use
Russian
the thing. So I'll say it
asset.
again, like I said in my
I'm
tweet.
a Russian
Wouldn't it be
asset.
great if House Judiciary
Russian
GOP actually
asset.
does something?
Okay. Okay, bye.
Unfortunately, those are the sentiments that govern my Republican colleagues here today. This hearing is not an attempt to conduct real, robust oversight of the Department of Justice, but rather an attempt to flog the Biden administration's Attorney General and to create an outlet to spew more ridiculous conspiracy theories. That's why they held a hearing on what they've termed lawfare, the ridiculous assertion that the department is somehow orchestrating state prosecutions of the former president
Russian
for
asset.
criminal activity
That's a
that
better
has
way
been
of
well
saying it.
documented.
Thank you. Oomph.
That's why the
that's
day after
more
Trump was
artful.
convicted on 34 felony counts by a jury of his peers, Chairman Jordan tried to drag Manhattan District Attorney Alvin Bragg into this hearing room to discredit the lawful outcome of the trial. And that's why they're making threats against and harassing the Fulton County District Attorney. They are trying to intimidate her out of going after Trump, or at least to proactively discredit any conviction that comes out of the election interference prosecution.
Yeah, it all works.
Extreme MAGA Republicans will use every tool they have to persecute, harass, and impugn anyone who dares hold Donald Trump accountable. That includes a special counsel appointed by the Attorney General to investigate Trump's role in the attacks of January 6th and his alleged theft of classified documents from the White House. In service of a convicted felon, they will have totally squandered their opportunity to do something meaningful for the American people. Their failure on this front stands in stark contrast to Attorney General Garland's tenure at the Department of Justice, which has done vital work in recent years to protect the interests of the American people. Under your leadership, Mr. Attorney General, the department is protecting consumers by ensuring Ticketmaster
Jerry,
can't
I'm glad
exploit
you
its
said
hold
that.
on the entertainment
Why, here's a slideshow right
is
now
fighting
of
to
all the
reduce
stolen
violent crime
documents.
and has helped achieve decreasing levels of homicides, gun assaults, and burglaries across the country. It is combating the fentanyl epidemic.
I don't believe it will
taking
be,
tens of millions
but
of
I haven't
fentanyl
seen
pills off the
anything.
street every year and
I
prosecuting
have to figure
traffickers
that
and
out.
dealers.
Thank you
It
for
is
the
defending
reminder,
reproductive
Siegfried.
freedom in light of Roe v. Wade's downfall, fighting to keep abortion, health care, and medications accessible to American women. It is ensuring our election infrastructure is safe and secure so that we have a fully functional, secure, and safe election this November without foreign interference. And so much more. This DOJ is doing important work, and we have the important job of making sure they do that work well. Unfortunately, Republicans on this committee, under the chairman's leadership, don't want to help DOJ employees do their jobs. They want to stop them from doing any work at all, taking them out at the knees, because that's what Donald Trump wants. These Republicans don't care what's in the interest of the American people. They just care about getting their favorite felon back in the White House. General Garland, thank you for being here today. I apologize in advance for the wild conspiracies and lies that will be told about you today. You and I do not agree on everything, but you are a man of great character and professional integrity. I take great comfort in knowing that nothing my Republican colleagues say about you here will change the thoughtfulness and decency that mark your leadership of the department. I urge you not to take this process too personally. The desperation has nothing to do with your record as Attorney General. Thank you for being here, and I yield back.
Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. The Honorable Merrick Garland is the Attorney General of the United States. He was sworn in on March 11, 2021. We welcome our witness and thank him for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witness has answered in the affirmative. You may be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony. You've done this several times before, Mr. Attorney General.
Yeah, he really has, because you're an idiot.
You can start with your opening statement. And I want to point out here at the
Why don't you point to the dinosaur?
Anytime you need a break, we're going to be here. We're going to have to go to the floor and vote. Anytime you need a break, just have your team get a hold of our team, and we'll be happy to do that. You're recognized for your opening statement.
He can't just pull on his ear or something?
Thank you, Chairman Jordan, Ranking Member Nadler, and distinguished members of this committee. Since I last appeared before you, the more than 115,000
let me find that piece, love. Hold on.
employees of the Department of Justice have continued their work to fulfill our mission on behalf of the American people, to keep our country safe, to protect civil rights, and to uphold the rule of law. Just 10 days ago, we secured the extradition of one of the lead sicarios, or assassins, of the Sinaloa cartel, one of the most dangerous drug trafficking organizations in the world. Just last month, we secured a 27-year prison sentence for a man who attempted to kill NYPD officers in a terrorist attack in Times Square in 2022. In just the first 3 months of this year, we charged 7 members of a hacking group backed by the Chinese government. We disrupted a botnet controlled by Russian intelligence services, and we seized over $108 million and 500,000 barrels of fuel that would otherwise have enabled the government of Iran.
Thank you, Gal. Gal dropped a couple tweets. Not at all. Don't. You're not a pest at all. Gal dropped a couple tweets there, and it looks like that'll have some information. So check that out. And at the break, we'll go ahead and check them out as well.
The largest one-year decline in 50 years is continuing. In the first quarter of this year, we have already seen an 18% drop in murders. We know we have much more to do. We have also remained steadfast in our commitment to the Justice Department's founding purpose to protect civil rights. We have aggressively investigated and prosecuted hate crimes that victimize individuals and terrorize entire communities. And we have brought justice to the perpetrators of those crimes, like the defendant in Florida who attacked 2 black women because of the color of their skin, the defendant in Michigan who defaced synagogues with swastikas, the defendant in Missouri who set fire to a community Islamic center, and the defendant in Tennessee who committed a series of arsons targeting Catholic, Methodist, and Baptist churches. We have worked to protect the reproductive freedoms that are protected by federal law. In Idaho, we sued to ensure that women in the state would have access to the emergency care guaranteed to them under federal law.
Perfect. Anna Bowers, who's amazing,
and to have that
on Lawfare. Lawfare blog.
Successfully challenged a
Bowers looks to be
redistricting plan in
starting a
Galveston
thread on
County,
it too,
Texas.
so Gal dropped a
District
link
Court
for that as
recognized
well.
that the plan
For
violated
breakfast,
Section
coffee,
2
and
of the
weed.
Voting
I don't
Rights
know,
Act
usual, the
by
usual.
depriving the county's
They went
black
after Apple.
and
Yes,
Latino
they went after
voters
Apple
of
Max.
an equal opportunity to participate in the political
New
process.
Ken Cheese, bro, James
choice.
Troopus, and
We have
Mikey
continued to
Mikey
prosecute fraud,
Roman
and we have
have
challenged
been
illegal
indicted
monopolies that
in
drive up prices
Wisconsin.
for consumers.
Each face
This year,
one
we
count
sued to
of
break up Live Nation
forgery in relation to
monopoly
the
of the live concert
2020 elector
We sued Apple for
scheme.
monopolizing
I hope they get
smartphone
conspiracy. I hope there's some super seedy
We have
indictments
also
on this
continued to
one.
fulfill our responsibility that underlies all of our work to uphold the rule of law. That is why we have worked to combat a worrying spike of threats of violence against those who serve the public. Those threats have included targeting of members of Congress, police officers, judges, jurors, election workers, and the Justice Department's own employees. Let me be clear. If anyone threatens public servants
in
with violence,
Wisconsin.
we will hold them accountable.
It's funny.
And we will continue
It
to
is
protect
funny.
our democratic institutions like this one and to bring to justice all those criminally responsible for the January 16th attack on our democracy. As Attorney General, I will continue to forcefully defend the independence of
I
the
love
Justice
Milwaukee. I
Department
had a great time in Milwaukee
improper
once.
influence or interference of any kind. And I will continue
I
to
fucking love
fiercely
that city.
protect
I'd move
the
there.
integrity of our
I'd move there.
criminal
That's how much I love
investigations.
Milwaukee.
Nothing will deter me from
Although the winters are
fulfilling
brutal.
my obligation to uphold the rule of law. Fulfilling that obligation includes ensuring that the Justice Department respects Congress's important role in our democracy. That is why we have gone to extraordinary lengths to ensure that the committee gets responses to its legitimate requests for information. That is why I have provided the committee with Special Counsel Herr's report, why the Special Counsel testified for more than 5 hours, and why we have gone beyond precedent to provide the committee with the transcripts of the Special Counsel's interview with the President. But we have made clear that we will not provide audio recordings from which the
Merrick?
transcripts that you already have were created. Releasing the audio would chill cooperation with the department in future investigations, and it could influence witnesses' answers if they thought the audio of their law enforcement interviews would be broadcast to Congress and the public. Now, in response, certain members of this committee and the Oversight Committee are seeking contempt as a means of obtaining, for no legitimate purpose, sensitive law enforcement information that could harm the integrity of future investigations. This effort is only the most recent in a long line of attacks on the Justice Department's work. It comes alongside threats to defund particular department investigations, most recently the Special Counsel's prosecution of the former president. It comes alongside false claims that a jury verdict in a state trial brought by a local district attorney was somehow controlled by the Justice Department.
Ooh, spicy
That
Merrick
conspiracy
today.
theory is an attack on the judicial process itself. It comes as individual career agents and prosecutors have been singled out just for doing their jobs. It comes as baseless and extremely dangerous falsehoods are being spread about the FBI's law enforcement operations. And it comes at a time when we are seeing heinous threats of violence being directed at the Justice Department's career civil servants. These repeated attacks on the Justice Department are unprecedented and they are unfounded. These attacks have not and they will not influence our decision-making. I view contempt as a serious matter, but I will not jeopardize the ability of our prosecutors and agents to do their jobs effectively.
Scott, what's his name? He's a fucking asshole.
Investigations.
Hey, Jim.
I will not be intimidated, and the Justice Department will not be intimidated.
That is
we will
funny.
continue to
Now
work
that
do our
is
jobs
funny.
free from political influence, and we will not back down from defending democracy. I look forward to your questions.
Thank you, Mr. Attorney General. We will now proceed under the 5-minute rule with questions. The gentleman from Florida.
I just had my Adderall and I got a clean shirt.
I have some unanimous consent requests.
That have to happen right now?
No, they could wait.
Okay, well, go ahead.
Mr. Chair, there was an allegation made in a letter yesterday suggesting that the FBI was somehow involved on January 6th. This is ludicrous, and you know it's ludicrous because witnesses...
Is there a unanimous consent request? Is there a unanimous?
It's not a proper unanimous consent.
I have some unanimous consent requests. I ask unanimous consent to enter into the record an excerpt from the transcript of the committee's interview with Steve D'Antuono, the former leader of the FBI's Washington field office.
Without objection.
Clearly refutes characterizations that the FBI was involved in inciting violence on January 6th.
Without objection. The gentleman from...
I ask unanimous consent to enter into the record an excerpt from the special agent in charge of the FBI Boston field office, in which he explains that conspiracies about the FBI causing the Capitol insurrection are false and concerning.
Without objection.
And finally, I ask unanimous consent to enter an excerpt from FBI Director Wray's testimony before this committee last July, where he states, quote, I will say this notion that somehow the violence at the Capitol on January 6th was part of some operation orchestrated by FBI sources and agents is ludicrous, and it's a disservice to our brave, hardworking, dedicated men and women. Close quote.
Without objection. The gentleman from Florida is recognized for 5 minutes.
Attorney General, you've told us that it's a dangerous conspiracy theory to allege that the Department of Justice is communicating with these state and local prosecutions against Trump. You can clear it all up for us right now. Will the Department of Justice provide to the committee all documents, all correspondence between the department and Alvin Bragg's office and Fonnie Willis's office and Letitia James's office?
The offices you're referring to are independent offices of state.
I get that. I get that.
State.
The question is whether or not you will provide all of your documents and correspondence. That's the question. I don't need a history lesson.
Well,
no, actually you do.
I'm going to say again, we do not control those offices. They make their own decisions.
The question is whether you communicate with them, not whether you control them. Do you communicate with them, and will you provide those communications?
If you make a request, we'll refer it to our Office of Legislative Affairs.
But see, here's the thing. You come in here
and
you lodge this attack that it's a conspiracy theory that there is coordinated lawfare against Trump. And then when we say, fine, just give us the documents, give us the correspondence, and then if it's a conspiracy theory, that will be evident. But when you say, well, we'll take your request, and then we'll sort of work it through the DOJ's
That's what it does. Hey, baby, those are the rules.
Then
Sorry,
you're
don't get to
actually
skip the
advancing
line.
the very dangerous conspiracy theory that you're concerned about. Now, you were a judge, once nominated the highest court in our country. When you were a judge, I'm just curious, did you ever make political donations to partisan candidates?
No.
No, and you didn't because
that's a good inside joke there, Peace Love. I like it. He's so unattractive. He's lost weight because Ginger body shames him and makes him go on a diet. And I'm serious about this. She's posted about it. She makes him diet.
Attacks on the judicial
she
process.
Fucking posts about it.
Someone be
She's body shaming him.
Like a jury of their peers and a judge that's non-biased, rather than getting a judge from your political opponent's
she's a little
donor file?
abusive. It feels. She gives me vibes.
You're asking me to comment on a jury verdict in another jurisdiction which has to be respected. I won't comment on it. That case is still ongoing. The defense
Mr. Attorney General, I hadn't asked you about the verdict yet. We were getting there. I was talking about the judge. And so let me ask you this question about your time as a judge. Was there ever a time when you were a judge when you had a family member
I can't diagnose. I'm just saying. Those are the posts I've seen.
Off of the notoriety of a case that was before your court?
Look, I'm going to say again, it's very clear you're asking me to comment on a case in another jurisdiction.
No, wait, hold on, Mr. Attorney General. Did you ever have a family member profit off of the notoriety of any case that you sat over?
Say again, you're asking
yes or no?
You're asking me to comment on a case currently.
Well, it seems you're connecting the dots, Mr. Attorney General. I'm just asking you as to a general principle, but you are aware that Judge Merchan's daughter was profiting off of this prosecution. You are aware that
That's
creates
not
the
true.
appearance of impropriety.
She was already working as a consultant before the case was
judges
brought,
giving donations
right?
Is because it is the very
I mean, I just don't think I get what Matt is doing.
I'm sorry,
oh,
I don't
Matt,
agree
you're
with
doing a
anything
great
you just
job
said,
for
but
the
I'm not going to
clips.
comment on it.
Okay,
do it for the
you
clips.
won't comment on it, Mr. Attorney General, but you had no problem dispatching Matthew Colangelo. Who's Matthew Colangelo?
That is false. I did not dispatch
He
Matthew
wasn't
Colangelo.
dispatched.
Matthew
That's
Colangelo,
false.
Colangelo became the Assistant Attorney General at the very beginning of the Biden administration. Without having been Senate confirmed, goes and gets this senior role at the DOJ, and then after, I believe it's Gupta replaces Colangelo, Colangelo makes this remarkable downstream career journey from the U.S. Department of Justice
Why is
in
it so
Washington,
remarkable?
D.C.,
That sounds like a feeling and not a fact. How many flags did your wife fly upside down in?
That's just a career choice that was made.
Mr. Attorney General.
That has nothing to do with the lawfare coordinator.
What is the position of your flag, sir? How is your flag? Without having been Senate confirmed.
I assume he spoke, he applied for a job there and got the job.
But see, you know
what,
what?
I had nothing to do with it.
Well, you
can't
might
remember
not have
who
had
the
anything to
one
do with
was
it, but
that he
we've got this
appointed.
contemporaneous evidence in Mr. Pomerantz's
Matt
book.
Whitaker?
So
Oh, like Matt Whitaker was.
which I'm sure you're aware of, where he says,
no, he wasn't
together the
confirmed
legal
either.
eagles
Oh,
to
yeah.
get Trump.
Yeah.
We got all these folks together and we assembled them for that purpose.
Oh, baloney.
So when we on the
Stop
Judiciary
it.
Committee think
What
about
happened first,
attacks on the
Matt?
judicial
Trump
process,
crimed.
our concern is that
And a jury of his peers, whether he likes it or not. Welcome to New York. That's a jury of your peers, bitch.
And then you assemble
and
the
they
legal
found you
talent
guilty
from DOJ,
34
Mr.
times.
And you bring everybody in
34
together.
times.
And meanwhile,
That's
the judge
so
is making
naughty.
money on it. The judge is making money on it.
Stop.
The judge's family's
This is
making money on it.
okay.
for
Where's
stuff
the
that you
decorum
yourself
in this
wouldn't
one?
do. You know, no one's going to buy this. No
If
one's
I
gonna
were
believe
him,
it. It's
I'd
gonna
Hillary
create great
Clinton this
disruption. And
moment.
I'm sad
Okay,
about it
I would
because, like
Hillary
you, I've
Clinton the
given my
fuck out
life
of this
to the law.
moment, and I'd be
I
like,
care deeply about the law, and I think that the lawfare we've seen against President Trump will do great damage well beyond our time in public service. I see my time's expired.
that's what I would do. I would Hillary Clinton the fuck out of this guy.
Thank you, Mr. Chairman. Mr. Attorney General, do you want to respond to anything in Mr. Gates'
Yeah,
tirade?
I know. I'm not a Michael Cohen fan, but I get what you're saying.
A case in another jurisdiction, an independent prosecutor, Mr. Pomerantz, worked for that independent prosecutor. I don't know Mr. Pomerantz. I don't know what's in his book, but these are decisions made in another office independent of the Justice Department.
I was reading the new
Thank you, Mr.
Twilight
Attorney General.
reboot. I
Last
didn't read
week,
his
as
book,
we all
sir.
know, a jury of his peers convicted former President Trump on 34 felony counts of falsifying business records of the first degree. The case was brought by the Manhattan DA, so it is a state case, not a federal case. I shouldn't have to ask you this, Mr. Attorney General, but since the majority seems to be confused, can you please explain the difference between a state case
Right.
and a federal
Ethics.
case?
Yes, the Manhattan District Attorney has jurisdiction over cases involving New York state law, completely independent of the Justice Department, which has jurisdiction over cases involving federal law. We do not control the Manhattan District Attorney. Manhattan District Attorney does not report to us. The Manhattan District Attorney makes its own decisions about cases that he wants to bring under his state law.
Thank you. My Republican colleagues seem to believe that the Department of Justice is secretly coordinating the now successful prosecution of former President Trump in New York. Is there any truth to this allegation? And what is your response to this allegation?
The case in New York is brought by the Manhattan District Attorney independently on his own volition and on his own determination of what he believed was a violation of state law.
Mr. Attorney General, 2 weeks ago, this committee took the extraordinary step of holding you in contempt.
That's a good one.
I want to make some things
Cooch
clear for the
doesn't need a
record.
history lesson, but
Since
could brush up on
2022,
federalism
when the chairman took
principles
over the committee,
and the balance
the
of
Department of
civics.
Justice has produced over 92,000 pages of documents and made 25 employees available for interviews. We've run the numbers. This is more than double the number of documents and exponentially more witnesses than the Trump administration's Department of Justice produced to this committee in 4 years. And with respect to the actual audio recordings sought by the majority, the Department of Justice has produced full and complete transcripts of the conversations memorialized by these recordings. Is that correct?
It is.
There's been an allegation that the transcripts might have been altered in some way. Is there any truth to that allegation?
There's no truth to that. The senior career official in the department, in a declaration he filed under oath, stated that he had compared the audio to the transcript and that it is an accurate, transcript is accurate with the exceptions of us and ahs and repetitions of words like I and and. And he consulted with Mr. Herr, the special counsel, and with the FBI agents in the room who agreed that who created the transcript and who agreed that it was an accurate transcript.
Thank you. One more question. Mr. Attorney General, throughout the 118th Congress, Republicans have made bogus allegations claiming that the Justice Department has been weaponized. Most recently, there was an allegation that the FBI was authorized to, quote, kill the former president. What impact does this type of rhetoric have on the career prosecutors and law enforcement agents at the Department of Justice?
This is dangerous. It raises the threats of violence against prosecutors and career agents. The allegation is false. As the FBI has explained, the document that's being discussed is our standard use of force protocol, which is a limitation on the use of force and which is routinely part of the package for search warrants and was part of the package for the search of President Biden's home as well.
Thank you.
So when former
Same
President
language.
Trump alleges that this was an assassination attempt against him, he is not telling the truth, either knowingly or, as is often the case with him, unknowingly.
I'm just saying that the
Maybe they're not awake yet.
Is not true. This is our standard use
There
of
might
force
be some more
policy, which
fireball
limits,
left in the bottle.
use of
You never
force that
know.
agents can use. It is used as routine matter in searches.
Yes.
That was a
Isn't that a coup?
court-authorized search. And
Attorney General.
Accompanied that
Is it
package
not
as
true?
it routinely does.
Thank you. So in other words, when former President Trump makes that allegation, he is either deliberately or, as is often the case, not knowing what he's, either deliberately lying or, as is often the case, not knowing what he's talking about. Thank you. I yield back.
Thank you. Mr. Attorney General, there's no blinking the fact that for the first time in American history, we do have a presidential administration that's working to put its opponent in jail. I mean, that's a fact. And that, an opponent who's a former president of the United States. Now, as I understand the facts, Jack Smith was the principal player in the IRS targeting of the Tea Party. He was a well-established record of prosecutorial abuse. And yet you appointed him to prosecute the former president of the United States, who happens to be running against your boss. Now, this is entirely new work, including approving an unprecedented search of a former president's home. And though you've just maintained that the local prosecutors are independent, it's a fact that in the Manhattan case, the third-ranking official in your department left it to join the local prosecutor's office to spearhead the New York prosecution. The Atlanta prosecutor strategized for hours with the White House counsel in advance of filing that case. And you've just refused Mr. Gates' request to reveal what communications your department and its employees have had with those local offices. So what are we to make of all of this?
The discretion of an investigation. The characterizations that you've made. We're happy to take into account the requests if you make them to us. That's the normal process, and we will respond.
That's what he said. He said, make the request. They'll look at it. That's how it works.
I disagree with your characterization that this person was sent by my office.
I didn't say he was sent, but it is rather odd that the third-ranking official in your office leaves it to go to a local prosecutor's office to prosecute this case.
Justice Department had nothing to do with that person
People
going.
move.
He was the principal deputy.
People move
to the
on.
third-ranking.
That's what happened. Sorry.
It's important that your
IRS. I know. That was a good one. That's not on my bingo card. IRS targeting of the Tea Party.
Special Counsel Herr concluded that although there was evidence President Biden had willfully retained and disclosed classified materials when he was a private citizen, his words, criminal charges were not warranted because, among other things, President Biden is, quote, sympathetic, well-meaning elderly man with a poor memory.
Oh,
do you agree with that decision?
baby.
I've said before, I'll say again, I'm not going to comment. I didn't comment on Mr. Durham's special counsel report. I'm not going to comment on Mr. Herr's.
Thank you.
Mr. Herr testified for 5 hours
Thank you.
before this committee.
This is a Department of Justice matter. You're the Attorney General, and there's no prosecution involved with this at this point. So
of course it matters. Mr. Herr explained the rationale for his decision in that case, and he explained the differences between that case and the case involving the former president.
Well, I do want to thank you for your testimony expressing concern for terrorist attacks. We've had 5 million illegal immigrants deliberately released into our country with very limited vetting.
Well, you're going to have to ask Mayorkas about
Has
that.
been overwhelmed, another 2 million known
Tea
gotaways
Party
have entered as well.
Yeah,
Now,
I
last
could
year,
see
your
it
FBI
being,
director,
you know, that's where I
told
think
this
that
committee
little
that he
libertarian
believes this
thing is sneaking in.
a massive security threat. Again, his words.
It's a good, that's
you agree with that
yeah,
assessment?
very hard to reason with.
I'm never going to be disagreeing with the FBI director, but my recollection, he said that there is a national security threat of people from known terrorist organizations crossing the border, and the FBI will do everything it can to follow those people if they manage to make it across the border.
I want to see her in some courtrooms as a defendant soon.
My greatest fear is that we could face a coordinated terrorist attack from elements among the millions who've entered this country illegally over the last 3 years. Is this fear justified?
I am worried about the possibility of a terrorist attack in the country
That's
after
his job.
October 7th. The threat level for us has gone up enormously. Every morning we worry about this question. We try to track anyone who might be trying to hurt the country. Of course, this is a priority, a major priority for the Justice Department.
Because of this administration's policies, you now have millions and millions who've been allowed into this country.
I know, but here's the thing, you're lying, number one. You don't know the numbers. Furthermore,
I worry about the stage is set for something
they
very
have
bad happening in the very near future.
Hundreds, or hundreds of individuals on various lists,
use Section 212F of the
and done probably a better job. You live an hour away from Clitta. Maybe I should trick or treat there. Oh my God! Oh, from the Coven. Oh my God! We should all like trick or treat. EO 13848. No.
But it is a lower number than your administration.
Here's 2011 Jack Smith. Oh, here's another. Gal's dropping another.
The president's maintained that he has no such authority.
Time machine.
What's changed other than
tweet.
5 months before the election?
I'm going to have to refer you to the Department of Homeland Security, which is responsible for the border issues. I would say that the best way to protect the border was to pass the bipartisan legislation that was proposed.
You're responsible. Well, the bipartisan legislation would have forbidden future presidents from using that very authority.
Gentleman's
time. Illegal entries reach 4,000 a day.
That's good enough.
Gentleman's time has expired.
Yeah, shut up. Shut up, McClintock.
I think we'll try to do a couple more questions, then we'll break for about approximately 15 minutes. Mr.
Oh
Attorney
my
General,
God, this is going to be a morning of breaky breaks.
The gentleman from Tennessee.
Thank you, Mr. Jordan. Thank you for your attendance here today, General Garland. I'm a little perplexed here. I'd like to ask you a few questions. They've raised the fact that this is the first time that there's been a prosecution of a president's allegedly gone after his opponent. Has there ever been another time in American history when a president was involved in an insurrection trying to overthrow the government of the United States of America other than January 6th?
The answer is no, but I do not intend to comment on the charges in the prosecution of the former president any more than I would comment on Mr. Herr's report. I just am not going to comment on matters that are before courts.
Thank you. It was said, somebody quoted that
who's saying?
One of the reasons there was no indictment of President Biden.
Who's talking?
On records, classified records, was because he was considered a sympathetic character. In the Trump case, did anybody consider him a sympathetic character?
I don't like questions like this. I really don't. I don't like those questions.
The fact that cases are
We're better than that.
I understand.
Just stick to the facts. Stop it.
Can't comment.
Mr. Jordan, in his opening comments, commented on the execution of the search warrant and said it was different in all these different ways. How many classified documents were found pursuant to that search warrant? And how many times have there been an attempt to get those classified documents and they've been refused to return?
So I don't know that, I don't have in my head the number. That's all on the public record, including the number of times that efforts were made to obtain through legal process the documents.
This whole hearing is about weaponization of the Justice Department and the suggestion that there was somehow your department was involved in the prosecution of Donald Trump in the state court in New York. As far as weaponization of the department goes, did the Justice Department indict Senator Menendez?
It's a matter of public record, yes.
And he's a Democrat, isn't he?
I'm assuming the answer is
Actually,
yes.
he switched to independent yesterday. Did you guys see that? He just switched to independent yesterday. Fucking
So
Menendez.
you've prosecuted Democrats, and as we speak, Hunter Biden, who is the son of the president, is under trial in Delaware. And so you haven't weaponized the Justice Department.
I like this guy a lot, obviously.
Democrats,
I like him,
Cuellar,
but
and Hunter Biden.
this stuff is like whatever. I get it. I get it.
And the law, we prosecute like cases alike, and we make decisions about different cases in different ways. We do not allow the political party or the ethnicity or the religion or the race or the wealth or the influence of someone we're investigating to make a difference in our charging decisions.
I noticed Mr. Gates, who took you on first, is not here now. And that's unfortunate because he is living testament to the fact and direct evidence that you have not weaponized the Justice Department. He was investigated for sex trafficking, and while many expected a prosecution, you chose not to prosecute this very active Republican. Is that true? You did not prosecute him?
I'm sorry, I'm not sure what is in the public record and what's not, so I'm just not going to comment on that.
Violent crime in urban areas is decreasing, and I thank you for that. Unfortunately, Memphis is not one of the cities where we've seen violent crime being reduced, but we're working on it. It was the second city to join the Violent Crime Initiative, which increases federal resources in specific communities. And I thank you for getting your department involved in trying to reduce murders and violent crime in our city, my city.
I feel like I've heard that
Resources have been helpful
today,
based on my
Max, but now I can't recall who said it.
Attorney, I want to thank you for that. Can you share some of the department's successes in tackling
Might have been
violent crime?
Jordan.
Well, yes, as I said in my opening, and I
He's
want to be
not
clear,
sure what's
these
on
are
the
not
public record,
Justice Department's
gal.
successes. These are the country's successes. Success in fighting violent crime relies on our partnership.
We have 105 total viewers. We have 20 here on YouTube. Thank you so much. This is the place to be. YouTube is the place to be because these are the smartest people on the fucking internet. And then we have one wonderful person on Twitch. Thank you so much. That means we have 84 viewers on Twitter. Thank you so much, Twitter. Thank you.
Wants to reduce funding to the Justice Department.
Thank you, everyone. I didn't mean just thank you, Twitter.
Certain
And thank you,
areas,
everyone, for
that
coming.
Would be defunding the Justice Department.
Media
defunding
literacy.
The opportunity to go after reducing violent crime. And I'm shocked.
Kind of hard. I was under 100. I was usually like in the 30s or 40s total with Twitter included. So, yeah, it's growing, which is wonderful.
Give or take
more media literacy. More media literacy.
Stand in recess.
Okay. All right. So we're gonna quiet that down, and then in the wah. I'm gonna close that for a second. Yeah. What was I gonna say? Oh yeah. No, it's wonderful. The viewers are tending to go up, and it's great to see Twitter. I'm so happy. This is why Twitter's, unfortunately or fortunately, Twitter is an important platform for my message because that's where I tend to have the most followers. I have almost 3,000 followers on Twitter. But you know, obviously, we're more intimate over here on YouTube. So yeah, that's why Twitter has been kind of, you know, an important platform for getting the message out. And the message is media literacy. Understand your sources. Understand, focus on facts. Media literacy, understanding what is in it for the media that you're consuming, what is in it for the author or the distributor of that media, what is their potential end game in that? Are they, you know, sponsored by a foreign government? You know, like things like that. So it's something that I feel very passionately about on this channel, and something that I try to focus on. And understanding media by looking at the actual original sources of what the individuals involved are saying. And that is critically important. To hear their actual words is really, really important. So that's why this is such a focus. and seeing the actual proceedings and reading the documents and, you know, just really trying to understand how we got here and how we navigate our way through it, so that we can have a more perfect union. And I really, truly believe, in addition to media literacy, that voting rights, securing voting rights and ending gerrymandering and ending, you know, dark money or PACs and Citizens United, taking that down. I think that those efforts are critically important to do first, frankly, because once voting rights are secured and once, you know, we end those other kind of manipulations of our vote, frankly, then I think we can begin. And disenfranchising voters is you know, one of the main activities of the autocratic kind of fascist machine that is kind of the body politic on the right at the moment. Certainly the loudest and most. It's kind of captured whatever it has captured. Although I heard some interesting, I don't like polls, but I did hear some interesting things about, you know, the line in the sand for independent voters and things. And this is coming more from right-wing media, which is always kind of interesting to listen to. I spend a lot of time listening to right-wing media. That's really kind of my fascination, is with how those messages kind of trickle down from, you know, the think tanks of destruction, right? Institutes of mass destruction, as Gal Suburban refers to them, where you have the Claremont Institute and, you know, the whatever, Klingenstein, what the fuck is his? Oh, I think he is the Claremont Institute. Whatever the other ones are. And the Council for National Policy, and you know, Tony Schaefer, like all these people, like all the kind of engineers of the fuckery, if you will, is what I like to call them. Having them kind of on blast and really understanding what they're saying and how they're trying to manipulate the public. And obviously it's worked on a certain segment of the public. I think they probably have some predilection to, you know, kind of the worldview, if you will. So I think we need to work on that. But at the same time, you know, that's why I don't spend a lot of time like trying to convince severe MAGA or libertarians, for that matter, about the wisdom of or lack thereof of their positions, because I think it's more important to focus on the results and making sure that everybody has the chance to vote and has the chance to be heard. So I think that is something that I care a little bit more about than trying to, you know, like convert MAGA. I do think we need to address and make sure that people have equal protection under the law. You know, the attacks on the LGBTQ community are unacceptable. The trans community, unacceptable. And I just see, unfortunately, that division and judgment and hate growing or not growing, but loud on the right, in the right wing media that I'm viewing, and it's very openly bigoted and still making, you know, like again, I think, you know, Trump gave permission for a lot of these things to be like endorsed by other politicians and other big voices in conservative kind of politic and media, and once that was given voice, you know, and said, oh, well, if they're saying it, I can say that too, right? So that's where I think it tapped into the worst impulses of people and made that something that was given more validity. Plus, I do believe the media has some fault in this for giving Trump and his minions the amount of attention. You know, for example, I spoke about this yesterday on a space. So every Monday we're going to do a space around either 5 p.m. or 6 p.m. I'm not sure where we're going to land completely, but we'll figure that out. Pacific. And it's really just to set the tone for the week. But we talked about the fact that, you know, we have the preliminary hearing of this Michigan fake electors. We've got the Arizona fake electors. We've now got the Wisconsin fake electors. So and we've got the Georgia fake electors. So we have like, you know, a fair amount of very complicated schemes that were intended to subvert the results of the 2020 election. And those pieces individually may seem, I don't know if you think of them as innocuous, but maybe there are people who do. But what is important about that is that the coordination and the amount of people and the names that keep coming up, Ken Chesbro, Mike Roman, we're going to have Ginny Thomas. We're going to have we're going to have these names continue to appear, Eastman, all that stuff. Those are the people that we need to start paying attention to, and to focus. And I think it's very important to focus on the New York trial for Trump. I understand that. I think in place of the fascination with what might have been happening on the outside or might have been happening on the inside, or if he farted or if he fell asleep or whatever, which is funny, great. In addition to that, could the media also have helped the public understand these more complicated schemes and who the actual planners and engineers of the ongoing insurgency? Can we talk about the ongoing insurgency? Can we talk about Mike Flynn and his very dastardly attempts at rebranding himself as a Kennedy Democrat, kind of not a party affiliated? I'm just a baby, This is Mike Flynn trying to rebrand himself as a victim of Washington, D.C. And he's doing a pretty dang good job for these fucking people who are ready. They're ready for some kind of, alternative, because their guy seems to keep getting fucking indicted and convicted. So for that, they need, I don't know. Yeah. And we have the DNC convention that is going to be a hotbed for foreign interference propaganda. Absolutely, peace, love. Absolutely. Hi, Basket Package. How are you? Good to see you. So I think that I would have liked to have seen some time in the media, and I know that there was some coverage. I'm sorry to make it such a generalization. I don't mean to do that. This is just a flashback. This is a replay. But I think that, oh gosh, I kind of forgot where I was. The DNC convention. It doesn't matter. I just think explaining, the different elements of the scheme, which in and of themselves, as we just saw with the preliminary hearing, is a very challenging set of facts to understand. And there is nuance to that case, obviously, as there is. So I just... I know we talk about Clarence Thomas being corrupted. I know that. But if we really focus on talking about, this is how Ginny Thomas actually helped steer activities in these cases in order to achieve an outcome that was not lawful, that was an attempt to disenfranchise the voters who voted legally. So that's the crime. Gal says, Odie and I put out a statement yesterday about Russian interference in 2024. I'd like to see that. Going into bad service area. Have a wonderful day. All right. Peace, love. Take care. Are they on a break? Yeah, they're on a break. The committee's on a break. They're voting. This is just an old replay. Let me go ahead and actually, I want to pull up. La, 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 la. Is that okay? Good. So there's this. I paused. Shite. I paused Michigan, so we can watch a little Michigan now. So anyway,
the Michigan Lottery Registration Act.
Whoa. What happened? Oh, I did that. I'm sorry.
Financial Disclosure Act. We also supervise local election officials in their responsibilities under the Michigan election law. They are independent elected.
No, I was finished. Thank you so much. I was absolutely finished.
They're working well with the election law. And we also operate the state qualified voter file and associated applications of that, which includes online voter registration.
Okay. And does the Bureau of Elections have any role in the national elections?
Yes.
And what is that?
Well, all federal elections are conducted under federal law, but also under the Michigan election law. So candidates for federal office, whether it be U.S. House, United States Senate, or President, those elections are held alongside other state elections, and they're held on dates and with procedures that are held in the Michigan election law.
And then, Angie, what has been marked as People's Proposed Exhibit 2, and ask you to look at that document. Do you recognize this, sir?
Yes.
Starting with the first page, could you tell us what that is?
This is an email that I received from Katerina Horska at the National Archives.
Okay. And is there a date on that document?
January 8th, 2021.
And do you recall receiving that email?
Yes.
Okay, and there's an attachment to that email as well, correct?
Yes.
Did you receive that attachment with the email that is the first page?
Yes.
And what is that attachment, sir?
It's a document that's entitled Memorandum, and it's from Kathy Burden, Chairperson, Electoral College of Michigan, dated December 14th, 2020. The subject line of the memorandum is Michigan's electoral votes for president and vice president. And it states that, I'll just read the document. It says pursuant to 3 U.S.C.
Oh, wait, I don't want you to.
Okay. It says that it includes copies of Michigan's electoral votes for president and vice president, certificate of the votes with votes for Donald Trump and Michael Pence, and it has a signed page from 16 individuals.
And I'm not sure if I heard this or not, but were you familiar with Ms. Horska before you received this email?
No.
You know where she works?
I believe at the National Archives.
Had you had any correspondence in your professional capacity with Ms. Horska prior to receiving this email?
I don't believe so, not personally.
And without reading the body of the email, what was the basis of the email?
She was informing me that she had received unofficial certificates from Republican electors that were not appointed by the governor, and that because they didn't come from the Secretary of State, they were not going to be adding them to the Electoral College website.
Now, looking at the remaining pages of that.
I just want to stop her for a minute because another thing about this particular fake electors case, which might be different from others, my understanding is that there was a point in time when Eastman, I think it came up in Jeff Clark's disbarment hearing actually in DC. But there was a point at which the language in the fake electors, whatever materials changed to include contingency. And I believe that language was started to be included in the Pennsylvania fake electors scheme. I'll have to recall the source for that, but I believe that's the case. And so in this case, there was not contingent language in the actual document. I don't know about the case in Arizona, whether or not that case, I believe that case also may have had the contingent, but I'm not entirely sure. Now, I'm not sure if that has implications because there might be evidence of the wider scheme to fake this, kind of have subvert basically the will of the voters by submitting fraudulent documents that were not founded in legally. And, different from Hawaii, 1960, where there was a coordinated public acknowledgement that both sets of electors would meet and sign pending the results of the recount that was underway at the time. So that is a very different situation from 2020. All right. They're back in the others. So I'm going to go back. Oh, no, they're not back. I'm so sorry. Here we go. We'll continue with this. Whoops.
Do you recall whether or not the Secretary of State had received that document before you received that email?
Not as far as I know.
And based on receiving that email with that attached document, did you do anything?
Yes, I contacted the Department of the Attorney General, Michigan Attorney General.
And why did you do that?
Well, this was an unusual document. It was unusual to get a document that was not the actual set of electors that had been properly approved. So that raised concerns for me. So I contacted the Department of Attorney General, and I think I also contacted the Michigan Department of State Legal Services Administration. I'm not sure who I contacted first, but I believe I contacted both of them.
And was it your hopes that this document would be investigated further?
Yes, I think it needed to be reviewed. Again, it was an unusual thing to see a statement of electors that were not the actual electors from the state of Michigan.
What moves to admit people's proposed Exhibit 1?
Objection to People 1.
No, I don't have an objection, but I didn't hear part of his answer. I think you said he contacted the Attorney General's office, and there was a second agency that he mentioned, and I didn't hear that.
Yeah, should I answer?
Yes.
The Legal Services Administration for the Michigan Department of State.
Okay, thank you.
I just want.
Sorry, People's Exhibit 1.
I was going to say.
Oh, I'm sorry.
Two.
Two.
That's what I was going to say.
I'm sorry. I was just so used to it being one. It is People's Proposed Exhibit 2. My apologies.
Okay.
Right, right.
Yes.
Okay, People's 2 is admitted.
Thank you.
Oh, I'm sorry. I didn't know my mic was live.
Now,
probably making noise.
in your answer, you stated that the attached document was unusual because it was not from the recognized electors. Is that a correct recitation of your testimony?
Yes, I think so.
Okay. Now, does Michigan have laws that govern how electors are appointed?
Yes.
And to the best of your knowledge, were those laws followed during the 2020 presidential election?
Yes.
Okay. Now, as it related to the popular vote in the state of Michigan for the presidential election, what is the process to determine, I guess, which party wins the popular vote?
Sure. So the presidential election
should he be testifying to that?
State essentially holds their own election. When it comes to the presidential election, first the major parties, Democratic Party and the Republican Party, both hold conventions after which they inform us who they've nominated to be the candidate slate for the Electoral College. So it would have been 16 individuals in 2020. When there's a separate process by which we receive the nominees for each major party for president. We then hold an election in November. It's a different date every year in November, that the names of not the electors, but the presidential candidates and vice presidential candidates appear on the ballot. Voters cast those ballots, they're paper ballots, they're tabulated by electronic tabulation equipment. Following that, there is a canvass. Each of the 83 counties has a canvass where they review the unofficial returns and make any corrections as needed. Each of the 83 boards of county canvassers, which are composed of 2 Democrats and 2 Republicans, then certify the results at the county level. Then there is a board of state canvassers meeting, which is also 2 Democrats and 2 Republicans. They then certify statewide the totals from all the 83 counties for all the offices on the ballot, including president. And then at that point, based on the returns that are certified by the state canvassers, we determine which presidential candidate received more votes, and those that candidate's electors are then determined to be the winners for purposes of the Electoral College.
I'm going to hand you what's been marked as People's Proposed Exhibit 3.
Media
Do you
literacy.
recognize that document?
Yes.
And what is that document?
This is the official canvass of votes for the Michigan presidential election in November 2020.
And what date was that document executed?
November 23rd of 2020.
People would move to admit People's Proposed Exhibit 3.
Objection to People's 3.
Objection.
Objection.
People's 3 is admitted.
I know, I've tried. I think it's the audio.
Contained in that document,
Everything's as high as it can go.
Identify which party won the popular vote for the as it relates to president and vice president in the state of Michigan?
Yes.
And which party won the popular vote?
The Democratic Party.
On the front page, there are 4 signature lines, correct?
Yes.
But there are 3 signatures.
Yes.
Do you recall why there are only 3 signatures?
In this case, one of the canvassers, members of the Board of State Canvassers, Norm Schinkel, abstained, I think, from the vote. And so he decided not to sign this document.
And does that